Good evening, everybody, and welcome once more to the Supreme Court of Kenya. And we have got hearing for several applications in petition number 1 of 2017. Okay, good evening, everybody, and welcome once more to the Supreme Court of Kenya. We have got the hearing of several applications filed in petition number 1 of 2017, Raila, Amolo Odinga, and another versus the IBC and 2 others. You are welcome, and please make sure your phones are off. Thank you, and welcome, Mr. CJ.
Thank you. I can see several councils standing. There are no seats? No, but they should have provided for those seats.
But they are very young advocates who we are urging to do what the profession requires. So the senior advocates can sit.
Esther, can somebody get some loose seats at least so that we have everybody seated? Sorry for that, Mr. Mwenesi, Mr. Gatia, as they bring the seats.
Thank you.
I want to take this opportunity to welcome you all to the Supreme Court. I want to start by recognizing the presence of observers. We have in the gallery judges from other jurisdictions who have come to observe what we do. Somebody was bringing me the names of the judges who are there. Do you have them? We'll get them. If it will not be discourteous, my lords, if I could ask you to just stand up and wave the judges from other jurisdictions who are with us here. Thank you very much. Welcome to Kenya and welcome to the Supreme Court. I also want to welcome all counsel. I think it would be in order if we have the lead counsel for each party to introduce their teams so that we know who is in, and then we proceed. You will forgive us, the courtroom is small, that's why we are so squeezed, but arrangements are being made so that loose chairs can be brought for other people to be able to sit. While those chairs are being brought, may I request senior counsel for each party to introduce their team so that we know who is who. Can we start with the... Yes.
Yes, my lords and my lady. I don't know whether to say good evening or good night. But we have the privilege and pleasure to appear before your lordships and my ladies. The appearances for the petitioners, there are 2 petitioners. Myself, although I appear together with my senior Firoz Norji, Senior Counsel, but I'm the lead counsel. James Orengo, together with Firoz Norji, Senior Counsel. Senior Counsel and Attorney General Emeritus Amos Wako is not robbed for purposes of today, but will be, in subsequent proceedings, be appropriately robbed. Senior Counsel Okongo Omugeni is in court. Paul Otiende Amolo, Dr. Mutaha Kangu, Honorable T.J. Kajuang, Mr. Paul Mwangi, Professor Ben Sihanya, Honorable Peter Opondo Kaluma, Madam Julie Soweto Aulo, Mr. Norman Magaya, learned friend Celestine Opio, learned friend Selma Achieng, learned friend Judy Olo, learned friend Willis Otieno, learned friends Anthony Oloch, Honorable Daniel Manzo, learned friend Ojeng Ogenga, and last but not least, our advocate on record, Mr. Jackson Awele. That is the entire team for the petitioners.
Thank you. Thank you very much. Thank you very much, Honorable Orengo, for the...
My Lord, I appear for the first respondent, that is the Independent Electoral and Boundaries Commission.
Please speak to the microphone, always.
For the first respondent, I appear with Senior Counsel Lucy Kabuni, Cyprian Wekesa, Eric Wumbo, George Murugu, Mahat Somane, and Sisulu. For the second respondent, that is the chairman of IEBC, Mr. Kamau Karori, appears with Professor PLO Lumumba, Issa Mansour, and Peter Wayama. We are following the order that Your Lordship said we follow. We had actually asked the Attorney General, who is the titular head of the bar, to introduce all of us, but you follow the order that Your Lordship indicated. Thank you.
Sorry for that omission, but
It's not quite an omission. He is not a party to this proceedings.
Whenever the Attorney General is present in court, he comes with his capacity as the titular head of the bar.
We are not sure.
Which is set out in statute. My lords will be guided by you.
very well, very well. Okay, let's go for the third respondent.
I hope the mic is on. Good. May it please you, my Lord Chief Justice, Your Ladyship, my Lords. For the third respondent, we have a team as follows. My name is Ngatia Frederick. I appear together with Senior Counsel Ahmed Nat Seal and my learned friend, my learned colleague, Ken Ogeto. Lean team of 3.
Thank you. Thank you very much.
My Lord, may I, with your permission, as I believe this is a record of the proceedings in general, indicate that I am present with Githu Muigai, Attorney General, intended amicus, and I am assisted by Charles Mutinda, State Counsel.
Very well.
With your permission, Lord Chief Chief Justice, my lady Deputy Chief Justice, judges of the Supreme Court, my name is Stephen Mwenesi. I appear in this matter for the Law Society of Kenya, an intended amicus. Present today with my learned friend, Mr. Kiari Mungai. We will be joined by Mr. Omwanzo Mbati, should we be allowed to continue. Thank you and good evening.
Thank you.
May it please you, Your Lordship, the Chief Justice, my lords, my ladies.
Please raise your voice if you...
May it please you, Your Lordship, the Chief Justice, my lords and my ladies. Harrison Kinyanjui, I appear with Kwesiga Malinzi for an interested party amicus upon your order, Professor Michael Wainaina. He was an independent candidate in the concluded election and will be presenting our position why he should be enjoined. Thank you, my lords, my ladies.
Thank you.
May it please the court, my lords, my ladies. My name is Charles Kanjama, and I appear as a proposed intended amicus for...
Thank you.
May it please the court. My name is Elias Mutuma. I appear alongside with my learned friend, Ignatius Mopia, for the first intended interested party, Dr. Ekuru Court. Thank you.
Thank you.
My Lord, my name is Kamodo Jenga. I appear for the ICT Association of Kenya as an intended amicus curiae.
Thank you.
May it please the court, my name is Isaac Aluochier, intended second interested party.
Thank you. Very well. Thank you for those introductions. First and foremost, I want to thank you all for the indulgence. I want to start with my colleagues who were kind enough to oblige me so that we are able to start at this time. And for you, counsel, to come in, I don't want to take this for granted. I want to thank you most sincerely for that recommendation so that we are able to start these proceedings at this time. As you know, because of the limited time, we may, on some other days, have to sit late, and I want to seek for the indulgence of all of us. Now, ladies and gentlemen, everybody knows that this is not an ordinary piece of litigation. It's not an ordinary piece of litigation. We all are aware of the time constraints, and unless we cooperate, we will have problems. So I want to seek your indulgence. I want to seek your indulgence, all of you, that when we start, first and foremost, let us have respect for each other. Absolute respect for each other. Let us conduct these proceedings soberly. I know the emotions of your clients. I don't want counsel to descend the arena of the clients, so that we are able to conduct the court business the way it is supposed to be conducted, with decorum, and as I've said, with respect for each other. And then we will move on fairly smoothly. That's why I said, please don't bring in any emotions from your clients. We are not here in a campaign forum, so let us restrict ourselves and deal with the matters that are before us. This evening, we have several applications. We have applications for people who want to be joined as amicus. Who are the parties who want to be joined as amicus? Once again, just the Honorable Attorney General, the Honorable, the LSK, Mr. Kanjama, and who else? Mr. Njenga.
ICT Association of Kenya.
Yes. We will deal with those applications and give rulings tomorrow. Now, we have applications by parties who want to be joined as interested parties. Mr. Kinyanjui, your client, Mr.
Elias
Mutuma, for Mr. Court, and yes, we will also deal with those applications and give our rulings tomorrow. This evening, we want, before we go to the pre-trial conference, there are two applications. Two applications seeking to strike out certain pleadings. Who are the applicants in these applications?
My Lord, may I, with your permission, for the avoidance of doubt, ensure that we have understood you. When you say, my Lord, that you will deal with the amicus application, does my Lord mean you do not wish us to make oral submissions? Because my understanding of the rules is that you could do, it is within your discretions, my Lord, to make that ruling without necessarily hearing the parties. And I want to be sure that I've understood you.
Very well. The applications have said we are going to give rulings tomorrow. We will deal with them on the basis of the pleadings and the replies.
I'm most obliged. I'm most obliged.
So those ones, we are not going to allow any oral submissions.
Most obliged.
The ones we want to allow very short oral submissions are the ones seeking to strike out pleadings. Who are those who are seeking to strike out pleadings?
My Lord Chief Justice, my Lords, the third respondent filed a motion seeking to strike out certain pleadings filed by the petitioner.
Yes.
The application has been responded to. We are ready and able to make very brief submissions in respect to that motion.
Very well. Which is the other application?
The opposite, an application by the petitioner, you'll say.
There's who is the applicant?
Yeah, we also have an application to strike out the
Yes.
responses from the respondents. That application will, on our behalf will be prosecuted by our learned junior, Mr. Wele.
Yes.
Yeah.
We have looked at those applications, Mr. Ngatia, Mr. Orengo, and Mr. Awele. The main ground is that those pleadings were filed late. Am I correct?
Yes.
Huh?
Served late, my Lord.
Served late. Whose was filed late? It is only service. It's only service.
My Lord, the application by the petitioner to strike out the submissions by the first and the second respondents, which submissions were filed on time, the only ground on which they are seeking to strike out those submissions
Is the microphone on?
Is on the basis that our submissions were served out of time. And I think you will notice from our response that our submissions were filed at 11 p.m. at night. We proceeded to the offices shown in the records here as a place for service of the petitioner, and we found their offices closed. We were there before midnight.
Very well.
So
Don't argue the application yet.
No, I'm just pointing out that is the nature of the matter.
Yes.
We filed in time.
Yes.
We sought to serve on time, but the offices were closed.
Yes. Now, our question is this, Council. You can't consent to this so that we are able to move rather than spend time on arguing whether or not an application or a pleading that has been served out of time should be struck out. We go and make rulings.
I wish I could make it easy for the court, but on our part, it's not possible because certain pleadings have never been served to date. They were not served in time. Even if we were requested to take them 2 or 3 days thereafter, we would have done so. But until to date, they have never been served.
Which ones are those?
They are on the face of the motion.
Yes.
We have tabulated each one of them. There are 2 sets of pleadings that were not served, then pleadings that were served on a Sunday afternoon without leave of court, and again, those have never been served on us. So it's not possible for us to consent on those things. If a request had been made by council, I would have been the first one to say, yes, let's extend time to council.
Yeah, but the request is now coming from court.
My Lord, our position is that we'd rather let every pleadings filed be allowed. That is because going through our brief is not quite correct that they filed in time and served on time. And we got evidence to show that that was not done. But because of the nature of this matter, we would rather everybody is fully heard, the responses are fully taken into account, there is nothing to fear, it's all about what happened and the law.
My Lords, I'd like to request you to take the speech made by the Honorable James Orengo to apply to my own application.
But my Lord, when he's admitted, I'll have no problem.
My Lords, Your Ladyship, we have one difficulty in going along with the suggestion made by my Lord the Chief Justice. Because the application we have made, that is the first and the second respondent, to strike out 3 volumes filed by the petitioner. Those 3 volumes relate to evidence, additional evidence, filed outside the constitutional limit of 14 days. So that is a difficulty that we have.
Very well. Very well. That being the case, Council, we want to start. We will give you 10 minutes each. 10 minutes each, strictly 10 minutes. And as I said, please let us have a cooperation. We have the what? Your applications. We will look at them. Let's see who starts. Who is seeking to strike out the pleadings by the petitioner?
We are, and our application will be argued by Issa Mansour. Well, we've been told to address the court. Yeah.
Yes, Mansour, you have had 10 minutes.
Yes, my Lord.
And please stick to that.
Yes, my Lord. We filed a notice of motion application dated the 25th of August 2017. We've served it on all the parties. And my Lord, on the face of it, we seek to strike out the following documents. The affidavit of Dr. Edgar Ouko Otumba, sworn on the 25th of August 2017. The affidavit of Norman Magaya, in support of the petition sworn on the 23rd of August 2017 and filed on the 25th of August 2017. There's a supporting affidavit of Omar Yusuf Mohammed, sworn on the 24th of August 2017 and filed on 25th of August 2017. And lastly, a supplementary affidavit of Ogla Karani, sworn on the 25th of August 2017 and filed on the same date. The reasons we seek to strike out this affidavits is that the petitioners filed a petition on the 18th of August 2017 within the constitutional time prescribed of 14 days. Within the time prescribed for filing the petition, pursuant to Rule 6 of the Supreme Court Presidential Election Petition Rules 2017. But the petition is defined under the rules to include an affidavit required to support the petition. And Rule 10 provides that the petitioner shall, within 2 days of filing the petition, serve the petition upon the respondent. Now, in terms of these affidavits, we had already first responded to the petition, having been served on the 20th of August with the petition and the original supporting affidavits. But these extra affidavits were filed outside the time prescribed for filing the petition, together with the supporting evidence in the affidavits. And more importantly, there is new issues that we have had no time to respond to. There is new causes of action, and they contain additional evidence that change the nature and the character of the petition, and it will prejudice both the first respondent's ability to respond to these affidavits as the pleadings have closed, as well as the second respondent, the chairman of the IEBC.
When did you say you were served?
With regard to the first affidavit of Dr. Edgar Ouko Otumba, it was served on the 25th of August 2017. Norman Magaya, it was also filed and served on the 25th of August 2017. Omar Yusuf on the 25th of August 2017. And lastly, the one of Ogla Karani on the 25th of August 2017.
So they were all served on 25th?
On the 25th, yes. They were sworn on different dates.
Yes.
But served on the same date.
Okay.
So, my Lord, for those reasons, as the first and second respondents will be prejudiced, they cannot respond to these affidavits in terms of replying by affidavits sworn on behalf of the first and second respondents. And more crucially, we had already filed our submissions and response to the petition within the timelines stipulated under the rules. And Lord, because they go towards prejudicing our client's right to a fair hearing, and no reasons have been advanced why they could not be filed within the stipulated time, Lord, we urge you to strike out these affidavits. They have been filed out of time, and the petition should proceed on the basis of the evidence that was tendered within the constitutional and statutory time prescribed by law. That's all, my lords, unless you have a question.
Thank you very much, Mr. Mansour. Who is next?
My Lord, Mr. Otiende will respond on our behalf.
Sorry?
Mr. Otiende Molo will respond on our behalf to that application.
Yes.
If it may please, my Lord, 3 quick responses. That application, my Lord, is based on a misapprehension. All the 4 affidavits spoken to are not filed in support of the petition, but they are filed in support of the application by the petitioner, which my lords are yet to hear. That is the application seeking various interlocutory reliefs. My lords will look at page 10 of that application, and we'll see that all those affidavits mentioned by Raila Odinga, Omar Yusuf, Dr. Edgar Otumba, Nyangasi Oduo, Norman Magaya, are in support of the application, not the petition yet. Second, my Lord, when we prosecute that application, as is clear in prayer number 7, we shall seek leave that other than being filed in support of that application, that this court be pleased to grant leave that those very documents also be filed in support of the petition. That has not come. Therefore, the objection is misplaced. Second, my Lord, the reason we take the position that Senior Counsel Rengo indicated is that if we start looking at who filed what document late and served late, almost all the pleadings filed and served by the respondents will be struck off. Either because, one, my Lord, that the very application to strike out was itself served out of your direction. It was served after 1 p.m. when the directions required that all interlocutory applications be filed before. That all the responses, as indicated by Senior Counsel Mwite, were not served within the time prescribed. The question of whether the which office was closed will invite us to cross-examine Senior Counsel Mwite as to whether he appeared in that office or not. So we were taking the easier option of saying, let all these documents be admitted, and we go to the substratum of the matter. And last, my Lord, that our overall position is to go to the substratum and not to invite this court to fall into the trap that is being set of going on technicalities rather than substantive justice. That is our response.
Thank you very much, Mr. Mamolo.
My Lords, we have 2 applications before you, both by notice of motion. The first one, court stamped 25th August this year. As regards that application, 25th August this year, there are 2 very, very unfortunate incidences or factors. In respect to the first set of documents, while as we were served with a petition on Sunday was 20th August, perhaps I could let...
Your time is still running.
Oh, we were served on 20th August at 5:15, while being served, and I hope this is common ground, it must be common ground, certain documents were not served. And those documents are tabulated in prayer number 1 in the notice of motion. Those documents have never been served to date. So, my Lords, I would have taken the olive branch if they were served on Monday or Tuesday. The position is they have never been served to date. And those are the documents in prayer number 1 in our notice of motion. In the same notice of motion is an incident that took place. On Sunday 20th, petitioner came to your registry at 1 p.m., procured a clerk to accept documents tabulated in prayer number 2, and they were...
Mr. Ngata, by procured a clerk.
No, cost. I think cost. Yes.
Procuring
will be that scientific, my Lord, henceforth. Caused a clerk to stamp the documents 18th. And I'm saying this not as something I am aware of. I became aware of it from the letter by your registrar. There is a letter from your registrar to that effect, that those documents were backdated 18th instead of the date that they were presented. Once again, my lords, I'll be the first to have indulged counsel if a request was made for an extension of 1 or 2 or even 3 days. But to cause a document to be backdated, coming from my legal training, is not the correct way. We should be priests at the altar of justice. We should be doing that which is correct instead of backdating documents. On the basis that those documents were backdated, my lords, we would urge that they be expunged from the court record. That's the first notice of motion. Second notice of motion, court stamped 26th August. After the close of pleadings, 5 new affidavits were filed by the petitioner, 5 new affidavits, raising new evidence. That evidence, my lords, under the rules and the protocol you have established, we have no time to respond to it. And these are 5 affidavits. So once again, my lords, we find ourselves at a very awkward position. That new evidence has been tendered. It should have been tendered with the petition. Our time for response has expired. And without any leave, and without even any indication that leave would be sought, with a corresponding increase for time to be given to us to respond, a petitioner has again caused the registry to accept pleadings or affidavits which would be very prejudicial to our client. So, my lords, will see the difficulty that I have, a difficulty which is a real difficulty. If these affidavits remain on record, I do not have the opportunity to cause my client to respond to them. There will be a real prejudice, not apprehended prejudice, but a real prejudice. Equally, if the first set of documents are again accepted to remain on record, there is a real prejudice to the third respondent. My lords, we have filed submissions in respect to both applications. We would urge you to allow them as requested.
My Lord, with your permission, again I'll respond to my learned friend's application. My Lord, the application being prosecuted before you was filed yesterday, itself after 1 p.m. If we were to go by my learned friend's implorations on time, the application itself ought not to be had, given your directions that all interlocutory applications were to be filed before 1 p.m. That is the first point.
What time did you say it was filed?
It was filed after 1 p.m. and served at 4:50 p.m. My Lord, the second point is that my learned friend's application, unfortunately, again, is a misapprehension and a misconception. My Lord, Dr. Nyangasi Oduo has two affidavits before you. There's his initial affidavit and a further affidavit, all filed and served in time. My Lords will notice in the schedule prepared by your registry that the first affidavit appears as number 4. The further affidavit appears as number 14. Both were filed and served on the respondents, and that they have not disputed. The misconception, my Lord, comes in the annexures. The first affidavit has annexures DNO 1 up to 7, and they are marked in volumes. The second affidavit has two sets of annexures, DNO 1A to Z. That is the annexures to the second affidavit. Malanan Senior obviously looked at the annexures to the first affidavit and only saw DNO 1 to 7. But the ones that he attacks in paragraph 1C is not only one, my Lord. It is DNO 1, 2A to 2Z. And they're in volumes which each of my Lords, I'm sure, have. They're marked from number 1 to 64. The second set is in the further affidavit, which Malano and friends attacked at part D and E. It is marked in the further affidavit as DNO 2A. The only indulgence that we were going to seek, my Lord, in that respect, is that the typographical area for DNO 2A was to read 3A only. But the documents and the volumes were filed and served in time, and they support the further affidavit.
So you say the only thing you are seeking is what?
My Lord, to correct the typographical error in paragraph 5 of Dr. Nyangasi's further affidavit, where it refers to the second annexure as DNO 2A. It should be DNO 3A to U. There are 19 volumes, all of which were filed and served in time. My Lord, lastly, the documents that we have referred to were all filed, served in time, and the evidence for that, my Lord, is not even for us to provide. The evidence is that each of my Lords will find that the documents referred to were with you. It is inconceivable, my Lord, that we could have sneaked into all your chambers and sneaked in documents as suggested by Malayan Senior. Thank you, my Lord.
Thank you. Thank you very much.
My Lord, I believe there was our own application to strike out which our learned friend Mr. Wele will prosecute.
Thank you, Your Lordships. My Lord, ours is a notice of motion application dated 26th of August 2017, principally seeking the first two prayers on the face of that application. The first prayer being, my Lord, the striking out of all the documents that were filed by the first and second respondents on the petitioners in response to the petition, and they are set out on the face of the application. And the second prayer being for the striking out of all the documents that, I beg your pardon, my Lord, the first prayer being for the striking out of all the documents that were served in response to the petition by the third respondent, and the second prayer being for the striking out of all the documents that were filed by the first and second respondents on the petitioners in response to the petition. My Lord, the application is premised on Rule 17 for the avoidance of doubt of the Supreme Court presidential election petition rules that permit any party wishing to file an interlocutory application to do so 1 day after close of pleadings. And that day was the 26th of August 2017. The substance of the application, my Lord, is premised on Rule 11.1 of the presidential election petition rules, which basically require any person wishing to file any response to a petition to do so within 4 days of the filing of the petition. My Lords, the petition was filed on the 18th of August 2017, and the same was served on the respondents on the 20th of August 2017, well within the time prescribed by the rules. My Lord, we were, however, served with the responses, all the responses that have been set out on the face of the application, on the 25th of August 2017, well outside the time stipulated by the rules for service of answers to the petition and all affidavits in support of the same. My Lord, the answer that my learned senior counsel Mwite attempted to give for the late filing does not sufficiently address the reason why the same was filed out of time, because even though our office may have been closed at 11 p.m., my Lord, the rules required the respondents to file and serve within 4 days. These are rules that the respondents were aware of. It was up to the respondents to make the necessary arrangements to make sure that as at the time that they file their documents, they should be able to serve the same on the petitioners. But even so, my Lord, the following day when the documents were ultimately served on us, they were served, the earliest documents that were served on us were for the third respondent, and they were served on us at 3 p.m. in the afternoon, and followed by the first and second respondents served at 3:50 p.m. in the afternoon. No explanation has been given, my Lords, for why those documents were served at that time, when it was well within their knowledge that the very nature of this application, and of course the voluminous nature of the documents that were eventually served on us, as you can see on the face of the application, would require the respondents, or rather the petitioners, to discern those documents and to prepare responses by way of rejoinder, as they are entitled to, as we are entitled to within the rules, within time. The same was served on us late. Pleadings have now closed, my Lords, and we are obviously, as Mr. Ngatia has stated, unable to get the petitioners to sufficiently appreciate the issues raised in the answer to the petition and the affidavits, and to instruct us on appropriate rejoinders for the same. To that extent, my Lords, the petitioners are equally prejudiced in the sense that they will not be able to exercise a right that is conferred by the rules to file a rejoinder. And of course, this then goes to the root of the right to fair hearing. As we speak, my Lord, we have not been able to prepare any rejoinder to the documents that were served on us late. And in fact, as at this morning, when we were filing our list and bundle of authorities, I was in the registry myself, and one of the documents that was also served late, and which is not in the application, was being served at the time. And that is the written submissions by the respondents. So, my Lord, for those reasons, we pray that the application be allowed with cause. Thank you, my Lord.
My
My Lords, on behalf of the first respondent, the application by the petitioner is opposed. And my Lords, the first respondent has opposed that application by way of an affidavit sworn and filed in this honorable court today by Mr. Moses Kipkoge. And I will be brief in my response, my Lords. The petitioner acknowledges that the responses were indeed filed in time. And my Lord, for the purposes of the response, it is important for me to point out that those responses were filed in the registry of this honorable court at 11:24 p.m. My Lord, that is important because this court had gone out of its way to ensure that its registry was open and its staff were available to receive the responses on the last day that they were due. Your Lordships will note that in the replying affidavit of Mr. Kipkoge, at paragraph 5, he deponds to the fact that at 20 minutes to midnight, 15 minutes after the documents were received in this registry, he went to the chambers of the advocates on record for the petitioner, and they were closed. There was nobody to accept service. My Lords, on behalf of the first respondent, I submit that in the same manner that the court had gone out of its way to keep its registry open, it was incumbent on the petitioner in this matter, or counsel on record for the petitioner, to ensure that there was somebody in their chambers to receive service of documents. There was nobody. And my Lord, it has come from counsel for the petitioner that the documents were served on them the very next possible day. Having filed the responses in time, my Lords, there was absolutely nothing the first and second respondents could have done to cause or to effect lawful service on the night of the 24th of August this year, as chambers, my Lord, for counsel for the petitioner was closed. My Lord, for those reasons, I do urge you to dismiss the application before you. The responses are important and they were filed on time. They were served on the 25th through no fault of the first and second respondent. And the first and second respondent should therefore not be prejudiced for that.
Thank you. Thank you, Mr. Nyamodi.
Most obliged, my Lord.
My Lord Chief Justice, on behalf of the third respondent, it's important, my Lords, that we put this matter in proper perspective. It is admitted that the response by the third respondent, together with all the replying affidavits, were filed within time. That is admitted. And there can't be any dispute because all this was being done within the glare of the media. We filed much earlier than respondent 1 and 2. The difficulty that arose on that night is that counsel for the petitioner hadn't done what we had done on a Sunday to make himself available for service. And that is pleaded or deponed to in our replying affidavit, that we made every effort to go to counsel's office, Mr. Awele, to go and effect service, and we found his chambers closed. What we all expected is that, as we had done much earlier, a few days earlier, is to make ourselves available for some service. Indeed, when they were serving the petition, we actually came over to his chambers to accept our service. My Lords, it's important we don't lose sight of one very important fact, that once we filed the response under your Rule 12, there is no rejoinder by the petitioner. Pleadings are closed. Hence, counsel cannot benefit from my argument to say that there will be prejudice there can't be prejudice because under the rules, the petitioner is not entitled to a further affidavit to respond to that which we have responded to. Another thing that, my lords, is important to put in perspective is that this application that we are now arguing before you was served upon us at 4 p.m. today. 4 p.m. today, as we are coming to the Deputy Registrar, is the time that the application was served on us. With a light touch, this shows the zeal and ability of the Council appearing before you. We are able to respond almost instantaneously. Within minutes, we were able to file a replying affidavit and written submissions. For the simple reason, my lord, that as my Lord Chief Justice indicated, we have a duty to do all that is within our power to expedite this process. This is an application which is a reaction to the two motions that the third respondent filed. It is a reaction, my lords, because Council is also trying to have a go at us, but his having a go at us is on a premise which does not exist under the rules. I would therefore request, my lords, to hold and find that while we served the following day, and we served a complete set. There's not a single annexure that was left out. We found a complete set of all the written documents, the DVDs, we served everything upon Council. My lords, which should not be faulted in any way. My lords, I would request you and urge you to hold and find that the application as a reaction ought to be rejected and to admit the documents as they are and to excuse the inability to serve before midnight on that date because there was no fault on the part of the third respondent or Council appearing for the third respondent. Unless my lords have any questions, as I indicated, within that time, I have filed and served written submissions and a replying affidavit. Most obliged.
Thank you, Mr. Ngata.
Thank you.
We'll deliver rulings on all these applications tomorrow.
My Lord Chief Justice, with your kind permission, there was one point I wanted to mention regarding my application, not an argument, it was a request to the court. And I would request your leave. There was a document that was filed late, one of the authorities to the application for joinder as amicus. I have explained this to my colleagues. The copies were availed to the registry and I hope they are with the court. This is an authority from a book on electoral jurisprudence that has been published with the assistance of the judiciary, I believe, and is on the chapter on amicus curiae. I'll therefore be requesting the court, I apologize I was not able to do this earlier, although I'd written an email, to include that as one of the authorities in the submissions of proposed amicus for myself. And lastly, there was also a failure to file substantive amicus brief together with the submissions. And using the same arguments that have been raised by my colleagues before this court, and also the fact that the proposed amicus brief should not duplicate arguments in the submissions of the parties, it was important that we awaited receipt of the submissions of the parties before we could file the amicus brief. So I would request also, on that same basis, that the court allow the amicus brief in the event the court was to admit my application to be filed within 24 hours thereafter on the specific items that have been indicated on the face of the application. That is all, my lords, my ladies.
Mr. Kanye, I understand you to be saying that the amicus brief you intend to file will be filed after the court has made a decision as to whether or not to admit you as amicus.
My lord,
because
the
basis upon which the court would make a decision is the amicus brief.
My lord, if I may respond to that very important question. Yes, the jurisprudence of the court is that parties who seek to be enjoined as amicus, first of all, do not have a right of audience prior to joinder. And secondly, they do not have a right to duplicate submissions that have been filed or will be filed by the parties. My understanding is that the substantive jurisprudence of the court militates against an intended amicus filing the substantive submissions, but they should show through the affidavit or the application their competence and the specific area where they would like to submit on the basis of that competence. So that even though there were some directions requesting for amicus brief, in my application, I made a specific prayer to be allowed to make oral and written submissions after the application for joinder has been heard, hopefully with successful outcome. Because otherwise, the amicus brief would not be targeted as required by the jurisprudence of the court. And those submissions were only uploaded on the website today. There is even one set of submissions that are still not been uploaded. And that is why I'm making this very humble request, because I do believe that the submissions of the amicus would assist the court very much beyond the partisan interests of the other parties to bring in the public interest element. That is all.
Lord, could we, now that is in the form of an application, respond in 1 minute? Now that it has been presented as an application.
Just a minute, Mr.
Counsel, Mr. Kanjama.
My lord.
I'm not preempting your application, and it will be hard on merit, subject to what the court says. But because of the nature of this matter and the time factor, don't you think your interest as Nairobi chapter of LSK could be well served by the principal and headquarters of LSK, the national LSK? Otherwise, if every chapter were to come in, it will never end.
My lord, that's again a very good question, and for purpose of clarification, my application is not made on behalf of any branch of the law society.
Are you coming personally?
Yes, I am coming personally.
Not as chairman of the chapter, Nairobi chapter.
I have indicated my various competencies, but the application is clear. Even though I'm in various organizations, it is my personal and professional competence that I seek to assist the court with. And that is why I set out my personal experience and not the experience of any branch or chapter.
Thank you, Mr. Kanjama. We will deal with that tomorrow.
Most obliged.
Yes. Now we come to the petitioner's application for is it access to information? Who is prosecuting it?
Yes, I will, my lord.
My lord, can I be heard before my learned friend prosecutes that application? My lord, on behalf of the third respondents, when that application was filed and certified by the court, an order was made that it be served only on the first respondent. There was no order that it should be served on the third respondent, although we are naturally an important player in relation to the same. So I would like to seek clarification on behalf of the third defendant whether that was just, a slip or a slight oversight, or whether it is a considered decision of the court that the third respondent should not participate in this. Secondly, my lord, that application is premised on a number of affidavits, which are the subject matter of the application argued by my learned friend, Fred Ngatia. So I'm of the considered view that until you make a ruling on whether those affidavits will be struck out or not, I don't think, my lord, it is the right thing for us to argue an application whose substratum is being challenged, or there's an application already that's before the court. So we will appreciate as a third respondent if we could get clarification on those two issues.
Mr. Menasir, don't you have a response to that application?
Yes, my lord, we have a response to that application. Yes, we have.
Filed yesterday?
Yes, we have a response. But we are just seeking whether, is that order, was it a considered view that we should not participate?
You have filed a response?
Yes, my lord, we have filed.
Yes, you will be heard.
We are most obliged.
Thank you.
And the affidavits, my lord?
Mr. Abnasir?
Yes, my lord.
Even in ordinary matters, you can raise a PO and the court tells you that we will deal with the PO in the main application.
I'm guided, my lord.
So we will deal with all those in the main application. Thank you. So who is prosecuting the application for?
I am, my lord. My lord, is there time indication for prosecution of this application?
10 minutes.
10 minutes.
10 minutes.
My lord, then if it's 10 minutes, then I'll try. Now, my lord, this application for access basically to information contained in the servers of the first respondent and logs and transactions to which ordinarily we would have access is premised on the prayers which are found in the petition. My Lord, you'd find that the prayers in the petition, the relief sought in the petition, number is found on page 22 of the petition, the paragraph marked E. My Lord, you'd find that from paragraphs A to G, the question of scrutiny and the forms used for the transmission of the presidential election results are specifically prayed for. And if you look at the body of the petitions, my Lord, in various paragraphs of the petition, the question of the relay and transmission of results is contained in the petition, together with the lack and failure of operational transparency. Those are matters which are specifically brought out as complaints in the petition. My Lords, when this court dealt with the first presidential election petition in 2013, the court came to the conclusion that the system of elections in Kenya is a manual system. Basically, that was the decision of this court. Since then, the position has changed by dint of various legislation, particularly the Election Amendment Laws 2016 and the Election Laws Amendment Act of 2017, in which the question of what is the system of elections is in Kenya. And my Lord, that question is addressed by Section 44 of the Elections Act as amended by the various legislation or statutes that I've referred to. And it says that, that there is established, that is Section 44, an integrated electronic electoral system that enables various functions which include voter registration, voter identification, and the transmission of results. My Lords, in that particular section, subsection 3, requires of the Commission to use such technology that is simple, accurate, verifiable, secure, accountable, and transparent. And that read together with subsection 5, which is the requirement for the Commission to develop regulations. My Lord, the importance of technology and the retention of records in the system that is used, the electronic system that is used, and access to the information that is kept in the electronic system in its various functions is underpinned by Section 44. My Lord, there was enabling legislation in terms of regulations which were passed, and those are contained in the regulations that relate to technology. My Lords, if you look at those regulations, particularly Part 3, which talks about testing, certification, and audit of technology, you will find the centrality of technology, the use of technology in elections, and that is for a purpose. The purpose is contained in Article 81 of the Constitution, which describes and defines the general principles of the electoral system. My Lord, in the petitions, some which have come to this court by way of appeals, that system has been elaborated and considered by this court on many occasions. But for the moment, I will deal only with the requirement that in any system of elections that is used, it is required that it must be transparent and administered in an impartial, neutral, efficient, accurate, and accountable manner. That read together with Article 86, my Lord, establishes the centrality of information in answering the question of accuracy, transparency, accountability, and credibility of elections. Now, my Lord, it would be not quite appropriate for me to quote Joseph Stalin, because we are not a Stalinist state. But Stalin said that those who matter in elections are those who vote, are not those who vote. Those who matter are those who count the votes. The crisis in Kenya has been not about those who vote, but those who count and how they transmit the result of what they counted in the elections. That has been with us since the year 2002, the question of transmission of results and how those results are transmitted. And therefore, through various legislation where the question as to whether results which are announced or declared at the constituency or the polling stations are provisional or otherwise, that question was put to rest by the legislation that was passed towards the end of last year and this year, that the votes that are counted at the polling stations and announced by the presiding officer and the collation and tallying of votes and the results thereof as declared at the constituency are final. So the question of transmission of those results through the third tier in the electoral process on election day is an important matter in regard to how those results are transmitted.
So, Mr. Rengo, what are you seeking? Your time is about to...
I'm sorry. So, my Lord, what we are seeking is that the forms, first of all, the forms that were used in the elections, Form 34A and 34B, would, that those should be, the original should be made available to the court. And, my Lord, the easiest way to properly show the court what the problem is, and in our application we have demonstrated, my Lord, that nearly all the papers from 34A and 34B that were delivered to this court by the Electoral Commission were either forgeries or they were forms which in one way or another were not authentic, and they were not the forms that were set out in the law. And for demonstration, my Lord, just I would invite the court to look at the exhibit DNO1 and is Form 34, document number 7. My Lord, if you look at the forms, first of all, they are not the same. There are some in which the names are different. Odinga, Raila Odinga. The security inscriptions which should be on the forms, the anti-copy security features are not there. And if you look at the end of those forms, the part where the total results for each candidate, you find there are some of them there and some are not there. So, my Lord, what we are asking, and the Electoral Commission should not fear this, nor should the third respondent, that we should look into these forms to find out. They should produce the originals because of the security features that were prescribed by the Commission itself and by the law. And finally, that because the electronic apparatus which are there in terms of servers should tell the whole story about the elections. And for those reasons, I beg the court that this application be allowed. Thank you.
Just a minute, a minute, Mr. Orengo, before you sit down. Although your time is up, we can extend a bit of time so that we are able to understand you. You want the entire, is it 40,883 they were? Forms 34A, if my correction is right.
Yes, yes.
Yes. So you want them produced so that?
We want them produced because what the Electoral Commission delivered within 48 hours
Yeah.
are not genuine Form 34As.
So what do you want? You want the originals?
We want the original ones, so
Yes.
that the return to the elections, looking at those forms, the court would be able to determine whether what has been brought to court were indeed the Form 34As, authentic and with all the security features, and even more importantly, the Form 34Bs that were delivered to the Electoral Commission. I'm allowed in the application, and looking at the affidavits, you'd find what we have disclosed as the problem with these forms that were delivered to court. They are not the authentic forms prescribed under the law, or they do not conform with the first and second respondents' security features, which again we are referred to in the application.
You don't have any particular forms you have flagged out? You want the examination of the entire lot?
We have flagged them all out. Like we have actually done an exposition of all the Form 34B and shown in every respect what's wrong with the forms that were delivered.
So those are the ones you want?
The 34B, 290 of them.
Yeah.
And the Form 34A, 40,833, I think, which are in the custody of the Commission. They were able to produce them to court because they had them in their possession. But our case is that what they deposited in court are not the forms that were actually used during the election process.
Yes.
Because examining them, they are not genuine documents, even from the photocopies.
On your own estimation, Mr. Orengo, how long will it take to examine those documents?
For example, for Form 290, my lord, from 34B,
yeah.
If I'm given 30 minutes, I'll be able to tell you.
Okay.
Right from the outset. In fact, my lord, one of the things that the Commission did when they gave us their forms, 34B, the one on top had the security features, which when you photocopy it, it shows the reading anti-copying. But the subsequent ones, when they were photocopied, some of them did not have that feature in them, which meant the originals did not have those anti-copying security features. And my lord, I can go on and on from 2090. Even the name of the candidates, there are some forms where the name of Raila Odinga is Raila Amolo Odinga. Some Odinga Raila. Uhuru Kenyatta, sometimes the name is Kenyatta Uhuru. They were used interchangeably. And some you find not only the names, but even the name of the political party. It's an entire mess, my lord. If you could look at these forms, you'd find that this election actually was not conducted in accordance with the rules and the regulations. And my lord, the importance of these forms, they are the instruments by which at the polling station, the decision to declare the person who won or lost at the polling station are contained in those forms.
You've said forms 34A, you will take approximately 30 minutes to examine.
1 hour. 1 hour. 1 hour.
34B, sorry, 34B.
Yes.
34B, you have said you
1 hour. And in fact, if I had assistance, it's an exercise that we have undertaken. If with the assistance.
Now you are moving to 1 hour from 30 minutes.
No, I'm saying even those 30 minutes will be quite appropriate and enough to expose this fraud, my lord.
Yeah.
And, looking at it even with an empty eye without using the devices for reading these forms, like there are cases where you find...
And 34A?
34A, that I'll need about 2 hours.
2 hours.
Yeah, so that's 3 hours.
What is the format of examination are you having in mind?
My Lord, for example, if I can show this Form 34B, my Lord, like this one, this is an authentic one. It has the anti-copying feature. It has a barcode. This barcode will show which constituency this particular form related to. There are some, when you use a bar reading device, instead of showing a constituency in Kenya, it shows some place in France, for example, or some institution, which is not the Electoral Commission. Then, my Lord, at the bottom, there's supposed to be a record of the names of the candidates and the votes that they received.
Okay.
In many, you do not find that in those forms they have a record of the number of votes found by a candidate.
Okay. Okay, very well. Let's see the other side.
Malal.
Mr. Rengo, that is not the only prayer you're seeking.
Yes.
So you've spoken about 34A and 34B.
Yes.
What about the KIMS kit? How much time would you require to do what you want to do with that kit? In terms of your estimation?
My Lord, the KIMS kit, in fact, we were talking to some experts who said that since it is just an access to know what transaction took place on polling day and the transmission of the results.
Because of time, just say 1 hour, 30 minutes, 20 minutes?
A day.
That is 12 hours, 24 hours?
I think more on the side of 18 hours. It will not go beyond 24 hours.
So 18 hours. What about the servers, the login trails of users? How much time would that take you?
I think together it will be those 18 hours.
The entire technological structure
yes.
and architecture would take...
That 18 hours will be enough.
In your estimation?
Yeah, in our estimation. Because you have to render a decision anyway within the next 4 or 5 days.
What about the saffron identity and security things? Would that be a separate thing or it would be the same?
My Lord, the saffrons were the providers.
But you want access to personnel and their technology. How much time would you require for that? This is important.
My Lord, I would say about 2 days. Yes.
Then the CJ asked you, and you sort of meandered away from it, in terms of the logistics of this, in terms of personnel, is it the court, is it yourselves, is it who?
My Lord, it can be court supervised, but the way we don't want to see the physical servers is only access to that information, which then will be possible without necessarily, bringing the servers in court. So long as we have the access to it, we'll be able to see all those transactions, including what was transmitted and at what time on polling day. We are just talking about essentially what happened on polling day.
So you're asking for print?
Because the printouts, that would be a manual exhibition of what is contained in the servers.
Yeah.
But once you have access to it, then you'd be able to see what is contained in the server. Restricted to the days which are applicable in terms of this election.
So you actually want to have the servers themselves and look into them, isn't it?
No, not we are talking about access. My lords, if you look at the regulations, they actually say these are matters which the commission should be able to allow those who want to seek information to have access to. And those are contained in the parts dealing with request for information and access to source codes.
So you want them opened so that you can be able to access?
Yes.
Okay.
Just one last question. Prayer number 11 of the application. You are seeking time to file further affidavits or supplementary affidavits in regard to this process.
My Lord, the affidavits that we were seeking, which are already part of this application, but we are seeking that those affidavits should be allowed or admitted for purposes of the petition.
The affidavits that Mr. Manzoor contests.
Referring to.
So that
they are properly in place for the application.
Understand
yes,
now.
Yes.
What about, you've done this access to information. You've received whatever information you're receiving. How does it come back to the court? By way of what?
I didn't get that, my Lord.
You are going to get some information from,
Yes.
if say the orders are granted.
Yes.
You're going to get that information to yourselves. How does that information come back to the court?
My Lord, we come back to court with that information.
How? A report, an affidavit?
We can download the information that is contained in the data storage of the server. We can come back with that information.
Thank you very much.
Yes. Because in the data, even the register, you would get to know what names are there, the voters, and those who voted. All that is in the contained in the data storage system, which is part of the server. My Lord, could I have 2 minutes for Ms. Otiende just to add something I may have?
Mr. Orengo.
Yes.
Please tell us how this exercise is going to be undertaken and by whom.
My Lord, that exercise can be undertaken under the supervision of the court, or it may be by way of the Electoral Commission giving access and giving confirmation whether what we come to court with by way of a report is actually information coming from their systems. Or the court can appoint the registrar together with the parties once that access is given, and that the information that would come after that access is given is brought to the court, a joint report, and if there are any objections or contrary opinion, they can be part of the report. Indeed, in 2013, this court undertook a similar inspection, although that was a manual one, and a report was brought by the registrar to this court. And I think, since technology is central to these elections, this is not an exercise that, my Lord, would take unnecessarily a long time if the elections was a manual election, where all the functions of the elections were manual. Once that access is given, my Lord, it could be even faster than the time frames I've given. I was going to ask for 2 minutes just for Mr. Tinda Molo to deal with the issue of the affidavits, which he had mentioned earlier. But that will be the end of my submission in respect of the prayers. But it will depend on the pleadings we have filed, the notice of motion, and the accompanying affidavits in regard to this application.
Yes, Mr. Amolo.
Thank you, my lords. My lords, in 3 minutes, 2 quick, clear points. Malanet Senior has prosecuted the application, but the particular aspect and what we are saying, my lord, is that the premise of the petition is that their first respondents servers were unbelievably infiltrated, and a constant of 11% difference between the petitioner and the third respondent maintained from the beginning to the very end for 2.5 days. We have the affidavit of an expert, Dr. Utumba, who says that is an impossibility. It is the belief of the petitioners that an audit of the website and portal, as sought in prayer number 4, will demonstrate the electronic footprints of those who interfered with that process. And that will be important to this court. And that will not be done in court, my lord. It will be done off court by the petitioner's own IT experts under the supervision, if need be, of the Chief Registrar of the Judiciary or other official. And all that this court will get after 20 hours, my lord, is a report on the same. The respondents, the first and second, the third respondent, has not shown whether they are interested or not. But if they are, then they could also be present. That is the entire prayer in terms of prayer 4. It is phrased in technical language, but that technical language is contained in the first respondent's own regulations, and it's also an expectation of the law. My lord, my last minute is on prayer number 7 in terms of the affidavit. My lord, those affidavits, as you will see, are important affidavits that will help this court establish the truth of the matter. They are affidavits that demonstrate that very point, and it is expected that the audit will confirm those affidavits. My lord, whether you admit those affidavits or not turns on only one point, my lord, Article 159 2D, my lord, which require of you, and I had the honor to sit with Lady Justice Njoki in phrasing this particular part, that justice shall be administered without undue regard to procedural technicalities. My lord, 4 years ago, this court unfortunately fell short of that article. My lord, we are inviting this honorable court to breathe life to the express words of that article, as have all the subordinate courts done, and that the affidavits by all the parties, as we said before, be on record, be tested, and the truth be established. That's all, my lord.
Mr. Molo,
yes, my lord.
Let me ask you one question. Do you know the time we are left with, the time we have?
My lord, I fully appreciate the time, and
Yes.
it is limited.
Yes.
Thoroughly limited.
Yes.
Yes, my lord. Our hope here, my lord, was that if my lords were to consider this application, and if you found it fit to grant it tomorrow morning, within the next 24 hours, as my lords are dealing with other matters, the audit will be going on. And by Monday morning or mid-morning, the report will be with this court.
Thank you.
Thank you, my lord.
My lords, your leaderships, I would like to respond to this application by addressing two different aspects of the application. One aspect, which is captured in prayer number 5, relates to the forms. You will find prayer number 5 at page 10 of the motion. That is where the petitioner is asking that the first respondent be compelled to give access and to supply to the court and to the petitioners for scrutiny certified copies of the original forms 34As, 34Bs, and 34Cs, prepared at and obtained from the polling stations by presiding officers and used to generate the final tally of the presidential election. Actually, it is 34As that were prepared and signed by the presiding officers at the polling stations. 34B was signed and is the aggregate of 34As at the constituency level by the returning officer at the constituency. So as far as the forms are concerned, I shall be addressing your lordships separately. The rest of the application relates to the ICT, to the systems. And I want to start by addressing that. My Lord, if you look at prayer number 3A, the petitioners are asking that your lordship should order us to give them direct, unfettered access to relevant persons. Those are not specified who they are, the relevant persons, and systems at Saffron in order for the forensic information technology experts to fully understand the KIEMS system. Now, to begin with, Saffron were the people, the company in France who supplied this system. So your lordships are being asked to make an order against a party who is not a party to these proceedings or to this application and who is outside this country. I have talked to our experts, and it would take a minimum of 3 weeks to implement or to carry out any of the orders that are being sought with regard to technology. When my learned friend talks about 2 hours, I mean, I don't know. It is not practical. It is not possible. But there is a second reason why the first and second respondents object to these orders that are sought with regard to ICT, which is integrity of the system. They're asking that they should be given access to the system, unfettered access. Who is to guarantee the integrity of the system, of this equipment? This equipment was not just about the just concluded elections. It will be used in future. It costs billions. If you compromise the integrity of the system, you would have to discard it in order to get fresh equipment, in order to carry out. It's not practical given the time remaining. And, my lords, remember that the petition was lodged on the 18th. Then the petitioners wait for a week to bring this application. No explanation has been given to this honorable court as to why this application was not filed simultaneously with the application. At least you would have had a little bit more time. And my lord, the petitioner's case is that the system was hacked. In fact, it's in the public domain. At one point, they even gave us the time of hacking, 12:36. Yeah. So they have the evidence on the basis of which they made such a grave allegation. Let them present that evidence in the prosecution of their petition. My lord, I think, my lord, Chief Justice participated in writing of a book here. There is a very good write-up, Scrutiny in Electoral Disputes, a Kenyan Judicial Perspective. And at page 261, my Lord the Chief Justice says, scrutiny is not to be granted on ambiguous pleadings intended to enable a petitioner to engage in a fishing expedition and perhaps enlarge his case beyond the scope of his pleadings. My Lord, a petitioner cannot be permitted to state the system has been hacked and then come and make an application in the nature of a fishing expedition. Give us orders to go into their systems to mine data to find out evidence of the hacking. It's for the petitioner to prove his case, my Lord, so that we, my Lord, seek to persuade this honorable court not to have any hesitation whatsoever in rejecting the orders or the orders sought with regard to technology. It is too late, it will take too long. It's not for this court to assist the petitioner to go looking for evidence. And I did not hear the answer to the legitimate, valid question that was posed by my Lord Lenaola. How will you introduce this evidence? Out of time, once you get it. How will you come and introduce it hereby? So we object to that. With regard, my Lord, to the forms which relate to prayer number 5 in the notice of motion. First, when your lordships and your ladyships retire, I invite you to look at paragraph 215 of the affidavit we have filed of Immaculate Kasait. Paragraph 215, where we set out the 8 security features in these forms. Form 34A, 34B, and 34C. Security features. In other words, it's one or the other. It's either the system was hacked or there was something wrong at the polling station. So that, my Lord, before I say what I want to say, the concession I would like to make in regard to the prayer about these forms, I would like us to be quite clear that Form 34A was completed in hand writing at the polling station. Once the votes were counted, on conclusion of the voting, the votes were counted in the presence of all the agents. And the votes of each presidential candidate was entered in hand in Form 34A. And that, the general rule, was witnessed, countersigned by the agent, it's a security form, and signed by the presiding officer. What am I saying? Is that truly the answer as to whether the system was hacked or not hacked is not to spend the next 2 months here, which we don't have constitutionally, with their experts saying the system was hacked, our experts demonstrating how the system was not hacked and could not be hacked. The answer is to look at these forms 34A and 34B, because 34B is the aggregate of 34A. They've asked for it, my Lord. A lot of false propaganda has been spewed out against us. My client, the client I represent, had no favorite candidate in this matter. Its job was to facilitate the sovereign will of the people of Kenya to be exercised in free, fair, transparent elections so that the Kenyan people could elect a leader, president of their choice. That's all. And for that reason, to demonstrate to this court, to the Kenyan people, that their sovereign will was exercised as evidenced by Forms 34A and Form 34B. Provided the examination is going to be supervised by this honorable court, we will make the originals available. They are here in Nairobi. But I ask that both sides, the petitioners and the respondents, should have their agents there, and these court's directions should be quite clear in my submission, namely that we are not to go there and take a lot of time arguing about the forms. The registrar of this honorable court, where a form is disputed, will make a report about that particular form. And I do think that if we did it that way, it will then be manifest as to how the sovereign will of the Kenyan people was exercised and who they elected. In other words, an examination of those forms will show whether the figures appearing in the aggregate of these forms tally with the figures that were announced by the second respondent. That is an exercise that can be completed tomorrow. And I do know that this court had suggested that we should begin the hearing tomorrow. When I was consulting with some of my friends, I am a communicant member of the Anglican Church. And a former chancellor of that church. But I do know that there is that passage in the Bible where one is permitted to pull out the donkey when it falls into a hole. But the others who feel they would like to go to church. So I was going to suggest, as I sit down, that perhaps if your lordships gave these directions, and that exercise was undertaken tomorrow, from morning through the day, through the night, we can come back here with a report on Monday morning and proceed with the hearing. I would like to ask my friend Issa to make 2 or 3. Sorry, oh, it is. You wanted to say that? Oh, okay. Then we'll leave it there. Issa will talk on behalf of the second respondent. Unless there is any question, my Lord, I have taken much less than my learned friends.
My Lord, the application by the petitioners is opposed on several grounds. First, we adopt this. I think it's not the microphone, it might be my height. I can push it. It is on. Yes, my Lords, the application is opposed, and we support the submissions on behalf of the first respondent. But the first point, the chairperson of the Independent Electoral and Boundaries Commission would like the court to appreciate. One of the prayers being sought is for the KIMS devices to be availed to the petitioners. These devices, as required under the election regulations, are kept at the 290 constituency tallying centers. It is impractical for these devices to be secured and transported from all the 290 constituency tallying centers where the returning officers have custody of these devices within the timelines anticipated by the petitioners. That's the first practical reality that has to be considered by the court. But the second one, and more importantly, is what was the role of technology in these elections? It was to transmit results from the polling stations to the constituency tallying center, and from the constituency tallying center to the national tallying center. The results were announced at the 40,883 polling stations spread out throughout the 47 counties. Now, my Lord, if the petitioners are contesting the results declared in particular polling stations, that what was announced is not what was transmitted, there would be a basis for some of the orders being sought here. The petitioners crafted has not identified the polling stations where results were declared and then transmitted through the system, and those results as received were different from what was declared at the polling station. When you identify, it can't be at large. We can't come and ask for the 40,883 Form 34As to be, because the transmission system only dealt with transmission. The results are at the polling stations. They are declared in Form 34A. You must first challenge a Form 34A, and when you go back and drill down to the petition, there's paucity of allegations against particular polling stations. Now, the rules about scrutiny and discovery in elections have been settled for a long time in this country. Does this application meet the threshold? It doesn't. It is a fishing expedition that hopefully something will come out of this exercise. Secondly, the commission is being asked to give, and the chairperson is in charge of this commission as the chair, as the titular head. The integrity of the system has been submitted on, but what are the practical implications of allowing outsiders to come into the system? One, the commission will have to be given adequate time to do backups, because the forensic tools that will be used to access could jeopardize and could make the system collapse. Before that is done, they have to secure all their systems. Can that be done within the strict timelines of this petition? Because then what happens to the integrity of these billions that we have sunk in as a country into the systems for the integrated electoral management system? It has to be secured first. We must do backups by the Commission's own technological experts. Their own consultants will have to come in. We secure each and every bit of these servers, and they just do not handle elections. They handle other aspects for managing and running the Commission. It's just not about electronic transmission of results. This investment has been put in over the last couple of years to ensure that the systems that are run by the Independent Electoral and Boundaries Commission work. In 2 years' time, we'll be doing the boundaries. So this investment has to be secured on behalf of the Kenyan people. If an order was to be met, then the court has to be alive to the fact that the timelines that are anticipated, it's not 2 hours for the backups. No, it's not. And even the forensic tools that will be used, they have to be tested to see if they're compatible with the system. All these are technological hitches that the chairman is alive to and is conscious about. And when you go back to the regulations, there are timelines within which any person would have accessed this information. The first prayer you see in that application is that they need access to stuff from people so that they can understand the KIM system. Will that be done within the context of an election dispute where the results are being disputed? If somebody wants to understand the KIM system, that is not for an election petition. That should have been done before votes were cast on the 8th of August. And there is provision in the regulations, the election technology regulations that were passed by Parliament, and there is provision in the Access to Information Act that they had a right to. They would have asked all the questions they wanted to ask about the KIMS and how it was going to be rolled out, and questions were asked and they were answered. This is not the application where now you start going back to rewrite the rules and asking for how the system works. We need to fully understand it, and then hopefully we can get something we can use in this petition. That is not the purpose for this election petition. And lastly, my lords, if we are going to go on the mode of the rules that of the application that have been given, the 4 affidavits that are being relied upon are not part of the record. Because when you look at them, they are titled Affidavit in Support of the Petition. Malala Senior and friend, Mr. Molo Tende, says they are seeking enlargement of time to introduce that evidence outside the stipulated 7 days within which the petition should have been filed. That evidence is inadmissible as a matter of law, because the petition and the supporting evidence go hand in hand. Now, that evidence cannot be introduced by way of an application. You cannot consider it in this application. It's new evidence. In terms of you considering whether or not to grant the orders that are being sought, or even to order scrutiny. Scrutiny is founded on the petition. It's not at large, or on the evidence that is tendered at the hearing of the petition. I understand under Section 82, under the provisions of the Elections Act, the court has a discretion, and even under your own regulations, to order scrutiny. but it must be founded on evidence. What is the evidence that has been tendered in the petition? Not these 4 affidavits that have come in long after the time for filing the petition has ended, for you to consider them in determining whether or not to order scrutiny. So, my lords, if you look at some of the information that is being sought, it's outside the purview and ambit of the petition. What are they challenging? They're challenging the results that were declared. What have the prayers that have been set out here got to do with this petition? In our respectful submission, nothing. It does not address itself to the petition. And for that reason, my lord, we urge you, on behalf of the second respondent, not to allow this application. We have limited time. The timelines that will be required to comply with this rule are not 1 day, not 2 days, at minimum. After the backups and everything is done, at least 3 weeks for the Commission to ensure that at the end of any exercise that will be ordered, they still have the electoral management system intact. That cannot be done as easily as is being presented here in the application. And simply, even if we were to consider getting the KIMS device, because this are part and parcel of the records for all the elections that were held, it will take at least 4 days to get all the 290 constituency tallying returning officers, bringing those devices to the head office, and then they're available to the court. At what point in time will the court be able to first get those devices and then embark on the exercise of agreeing on the parameters upon which these devices, which are expensive, should be used for purposes of assisting this court? In respectful submission, this application ought to have been presented 7 days ago for it to be fully considered on merit. For now, it's an attempt to get new evidence, and that should not be permitted. Unless you have any question on behalf of the chairperson, we urge you not to allow the application.
My lords, with your kind permission.
Who are you appearing for?
I'm appearing with Mr. Issa for the second respondent.
You know, if you are doing that, look at this, the clock, and share the time accordingly.
Yes, my lord.
Because you see, if you are going to, he finishes the time and then you start on your own, we are going to run into problems.
My lord, there was a minute remaining. But
okay, go on.
My lord, there are only 2 issues, my lord, that I wanted to bring to the attention of the court. Based on the submissions, written submissions filed by my learned friends, and I would like my lords to look at paragraph 5 of the submissions that they have filed, the written submissions. My lord, the petitioner says, the petitioners contend that the said omission, the same transmission system was in fact not secured as by law required, and in light of the startling discoveries. So they are saying they have made startling discoveries already, have uncovered the petitioner's claim that the first respondent system was tampered with is vindicated. So they already have material showing, according to them, that the system operated by the first respondent has already been tampered with. What is the purpose of the exercise that we are being asked to allow if they already have the information? That evidence should be tendered, or they should have tendered that evidence for consideration by the court. So that basically what they are doing, my lord, is saying we already have the evidence, but we just want to be allowed access to the system. That is one, my lord. The second one, my lord, the respondents say that that the results that were procured, they have discovered that the results that were announced were actually not the authentic results. So that they already have the information that, according to them, the evidence, the results that were declared by the second respondent are not authentic. If they already have that information, why is this application being made? And so, my lord, that is why we are saying that at the end of the day, the exercise that you are being asked to undertake is a fishing expedition. But finally, my lord, and I think it is important that when you are considering such matters, we take judicial notice of certain aspects. If, my lord, you are to look at 40,883 return from 34A, it is not humanly possible to look at 40,883 forms within 30 minutes. It's not humanly possible. And so, my lord, the court should take into account the time that in reality would be required to go through a total of 40,000 forms. Even if you're going to take 2 minutes per form, how much time will that require? And so, my lord, we do not want to find ourselves in a situation where if these orders are granted, you are now told, my lord, that the time that has been allocated, 30 minutes or 1 day, is too short, and therefore time is asked, additional time is asked, and yet it is not available. So, my lord, just to say what my learned friend had said, there was opportunity time for this application to have been made at a time when this exercise could have been carried out with sufficient time available. And what would not want to happen for those who appeared, my lord, earlier in these proceedings is a situation where now a party is asking to be allowed access to information, and then they will say the argument will be that if they are given only 1 day and they have not been given sufficient time, evidence has been locked out. Let them produce the evidence they already say they have. That's all, my lord.
My lords, mine is a request. At the conclusion of his submissions, Senior Counsel Mr. Muite made what he said is a concession, but which I understood to be a very practical solution. Practical solution because according to him, numbers will be demonstrated. And we all know elections are won by numbers, not hypotheses. The difficulty that my friend and my colleague, we both have is this. We do not have instructions on what to say to that practical solution. And we would not wish to think on behalf of our client about that concession. It has taken us by surprise, my lords, and it's on that basis that we request you very, very, very humbly, if you'd allow us an opportunity, even 10 minutes, to seek instructions on that concession made by Mr. Muite, because it changes the approach we would have had to this application. And it's a point that was made so forcefully, and it must have some consequences to whatever decision that will be made. Would you please allow us just 10 minutes to seek instructions?
So you would rather we adjourn for 10 minutes?
We are really requesting you,
so
my lords.
You consider that?
Yes, because we will not wish to say anything from the hip. We would rather got instructions and respond to that aspect by Mr. Muite. And you will agree, Mr. Muite is a very honorable gentleman, that he never whispered that point to us at all.
Yet we are independent. No, there's no reason why I should whisper to
We respect his independence, and I'm sure he never whispered to Mr. Orengo as well, no, to Senator Orengo as well. And within the 10 minutes, we'll see how to respond to that point.
My Lord, my Lord.
Nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi ya badilika, in the future mavijana si kila saa kushinda njaa. Atonjo karao, wanyono karao, opera kakao. Atonjo karao, wanyono karao, opera kakao. Mwangaza bila wasitotaka, mabadiliko bila unavyoweza, tuwe salama.
strange request, as we thought, because this is a matter which is entirely in the custody of a public body. And once that concession was made, I do not think that the instructions being taken on behalf of the third respondent has anything to do with a public duty which is vested on the public body.
We'll give you time to respond to that.
Yes.
Because he's a party, yes, and he's entitled to respond to the application. Mr. Ngatia?
My Lord.
We'll give you 10 minutes. We'll adjourn for 10 minutes. Come back so that you make your submissions and Mr. Rengo wraps up and we move on.
Most obliged, my lords.
Thank you.
Thank you very much.
All rise.
Mwangaza bila wasotaka, mabadiliko bila unavyoweza, tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele. Tusawazisha mabadiliko, tusawazisha mabadiliko, badilisha.
Vote for Raila Amolo Odinga. Pigia baba kura. Mambo yabadilika.
Mwangaza bila wasotaka, mabadiliko bila unavyoweza, tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele. Tusawazisha mabadiliko, tusawazisha mabadiliko, badilisha.
Raila Amolo Odinga. Pigia baba kura. Mambo yabadilika.
Located in East Africa, Kenya is bordered by the Indian Ocean. It also is part of Africa's second largest lake, but is inaccessible to the majority of the Kenyan population. Kenya has suffered from multiple harsh droughts in current years and in past decades.
Every night in my dreams.
A 100 to 1,000 children died under the age of 5 every day due to drought.
Tunataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi yabadilika. In the future mavijana si kila saa kushinda njaa. Tusawazisha mabadiliko,
mwangaza bila wasitotaka mabadiliko bila unavyoweza tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi ya badilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao.
Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha. Mwangaza bila wasitotaka mabadiliko bila unavyoweza tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi ya badilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao.
Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha.
Vote for Raila Amolo Odinga. Pigia baba kura. Mambo yabadilika.
Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko.
Vote for Raila Amolo Odinga.
Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha, twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi ya badili kushinda njaa. Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Tuwe salama, wewe pia wajibika. Ni mtoto wa kika, baba yuko mbele.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi yabadilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Tuwe salama, wewe pia wajibika. Ni mtoto wa kika, baba yuko mbele.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wasi yabadilika. In the future mavijana si kila saa kushinda njaa.
mwangaza bila wasitotaka mabadiliko bila unavyoweza tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wazi ya badilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
mwangaza bila wasitotaka mabadiliko bila unavyoweza tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wazi ya badilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opira kakao. Adonjo karao, wanyono karao, opira kakao.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
mwangaza wasitotaka mabadiliko bila unavyoweza, tuwe salama, wewe pia wajibika, ni mtoto wa kika, baba yuko mbele.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Yes, Mr. Ngatia, now you are.
My Lords, thank you very much for the time you gave us. We have been able to consult our technical team.
Yes.
And we'll take the application in two ways. First, the way we had anticipated to argue, and number two, a direct answer to the practical solution by Senior Counsel Moite. So Ahmed Nasir will deal with the first part, and I'll deal with the second part.
Both of you have 10 minutes, so can you do that?
Yes, we'll do it within 10 minutes.
Okay.
A little longer, because I think Senator Orengo almost took 30 minutes, but we'll not rival him. We'll take about 12 to 13 minutes.
Very well.
Thank you, my Lord.
Thank you, my Lord Chief Justice and Judge of the Supreme Court. My Lords, we are opposing this application, and I think the starting point is not to lose sight of what is before this court. And my Lord, what is before this court is a petition filed by the petitioner defining the contours of his petition, which is a 23-page document. In that petition, he pleads his course of action, which is divided into various paragraphs. That course of action is captured in paragraph B and part B and part C and part D, where he asks the court to determine certain questions. My Lords, it is a basic principle of law that parties cannot depart from their pleadings. Whether it is by a plaint, whether by a petition, or whether by summons, a party must limit his case or define his case as pleaded. But now we have a case, we have an application before this court, where the petitioner goes to a different trajectory. He goes to an area that is unpleaded, that is different from his course of action, and which enlarges his course of action well after the pleadings have closed, my Lord. My Lord, if you look at this notice of motion, what is the essence of this notice of motion? It is a petition under Article 35 of the Constitution, the right to information. And my Lord, one of the basic issues we should appreciate is that there is a difference between the right to information under Article 35 and the right or a demand for evidence. The petitioner in this case is not saying that I need this information. No. He is saying I need this evidence. He is saying that my case cannot go forward unless I am supplied this evidence. And that is so clear from the affidavit by the Honorable Raila, my Lord. And I will read for you the pertinent paragraphs where he says that if I don't get this evidence, my case is over. My Lord, I draw your kind attention to paragraph 19 of his evidence, where he says, I'm advised by my advocate and experts on record that all these issues, which he enumerates in paragraph 19, A to I, unless I'm granted, my case cannot go on. I also draw your attention, my lords, to paragraph 20, paragraph 21, 22, 23, 24, 24, 25, my lord, it goes on up to the whole evidence. But my lord, it is my humble submission that it is not the function of this court to help a party build a case different from the one he has pleaded. The onus for him is to prove the case as pleaded, my lord. This court cannot order, respectfully, my lord, that the court or the parties should supply the petitioner all this evidence so that he can have a course of action, which is not part of his petition. My lord, we have been here 4.5 years ago. The same case, the same pleading, the same issues raised, and this court, my lord, reached their decision when it rendered the decision on 23rd March 2013. And my lord, I will give you copies of the ruling, where the petitioner made the same application, requesting the same information, well after the pleading have closed. And my lord, I will kindly draw your attention to the judgments of this court at paragraph 3, the second paragraph and the third paragraph, where you said, my lord, that this application cannot be granted on the reasons you advance in that judgment. And my lord, there is no, in my respectful submission, my lord, there is no reason to depart from your decision. You address the issue of Article 159, and this court rightly said that if it is a technicality, it's a constitutional technicality that this court cannot do anything about it. My lord, again, if you look at the prayers, and I think my learned friend Honorable Mute went through it,
you have not highlighted our copies.
Yes, my lord, my assistant didn't highlight, but it's page 3, my lord, the last two paragraphs. If you look at page 3, the paragraph that starts, ideally an intended petitioner must utilize the 7 days, but the one, my lord, that captures the ratio of the case is the last paragraph that reads, applying this principle to the application at hand, it becomes clear that the court cannot grant the order sought without seriously jeopardizing the hearing of the petition.
Very well.
Yes,
Very
my
well.
lord.
Yeah.
So that, my lord, we find ourselves in the same situation, 4.5 years, the same issues and the same applicant. But my lord, if you look at even the prayers, and my learned friends have gone through this, if you look at paragraph prayer 3, where the petitioner requests for a direct and unfettered access to relevant persons. My lord, who are these persons? Where are they domiciled in? Are they domiciled in France? The systems of Saffron, my lord, Saffron is not a Mickey Mouse company. It's a Tier 1 technology company in France. These are not companies that will allow you to check their systems. We need, all these issues, my lord, are almost impossible to get. Look at my lord, paragraph B, unfettered physical and remote exercise. C, D, E, my lord. My lord, look at paragraph 4, where it says the Honorable Court be pleased to order the first respondents to have access. My lord, there is no law in this country that says that a public body cannot defend itself when sued by a citizen, my lord. IEBC has all the rights to decline to give this evidence, my lord. What the petitioner wants, my lord, is to cannibalize the system, to vandalize, to cannibalize really all the systems of the petitioner. And my lord, there is no authority, there is no legal proposition that says that a public body can be compelled to help in the case of a petitioner, my lord. So, my lord, on all those issues, it's our humble submission that it's simply impracticable. It's simply not tenable. It's beyond the scope of the petitioner's petition, my lord. It introduces many areas that are not pleaded, many issues that have not been pleaded, and it will prejudice, my Lord, the third respondents if the petitioner is allowed to have this new information, which we cannot have an opportunity to oppose or verify. My Lord, I will give my learned friend the remaining minutes to address the other portion.
My Lords, as regards the proposal made by Senior Counsel Muite, I start, my Lord, with on a common ground that in the 40,883 polling stations in the Republic of Kenya, which were the primary voting units, every candidate or every of the presidential candidate was entitled to have agents, and the agents must have had copies of Form 34A. It is not a favor, it is their right to have Form 34A. And every candidate was entitled to have agents in every polling unit. From 34A, my Lords, which the Court of Appeal described as a final result, those results will be transmitted to the constituency and tallied. I come to the point. And tallied, and the Form 34B will be produced. Once again, candidates' agents would be entitled to those forms, 34B. What am I driving at, my Lords? Forms 34A and 34B, every candidate's agents would have them. It's not a new document to a candidate. It is a candidate, at the conclusion of the electoral process, the candidate would get all those forms from your agents. Hence, my Lords, turning to the request by learned Senior Counsel, within those areas that there is a contest by the petitioner, the electoral areas that there is a contest by the petitioner, this Honorable Court could order a tarring process, a tarring of 34A and 34B. By tarring, my Lords, I mean, and I ought to make myself very clear, it is a tarring number for number. It is not another contest in another area. It is number for number. My Lords, that process could be undertaken within an inbuilt process by this Honorable Court, a process that would define the time, define how it is to be undertaken, and define that parties' representatives will be present to merely see the tarring process. My Lords, it shouldn't be another process of another contest. It is merely a tarring process. When I say this, my Lords, we are making that very limited concession on the basis of trying to assist this Honorable Court to come to a very speedy conclusion. My Lords, otherwise, our primary submission is to contest and to oppose the application in its entirety. That is our submissions, and that is what we have been authorized to do, to defend and to oppose this application in its entirety. But if that window of opportunity were to find favor with the court, and the court were to have inbuilt mechanism, my Lords, our client has no difficulty with doing that because, my Lords, as I indicated, elections are won by numbers. And those numbers will show who, even in those areas that there is a dispute, who had what numbers and who had whatever other numbers. My Lords, unless you have any questions for me, I think we have concluded our response in full.
Thank you, Mr. Ngatia.
Most obliged.
Yes.
May it please the court, there is a technical issue that has been addressed, and I was going to seek the leave of the court. Just one point. It's a technical point.
As you know, Mr. Kanjama,
yes,
you have not even come on record. You have not come on record.
Yes.
So, I mean, how do we allow you to come in? If we allow you to come in, we have no reason whatsoever denying anybody else coming in.
My Lord, I appreciate that situation. What I'm noticing is that we have advocates.
No. We can't go on like that. You know the procedure, Mr. Kanjama. Please sit down.
Okay.
Please sit down. Yes, Mr. Any response?
Yes, my Lord, how many minutes? 10 minutes? Yes, my Lord, in response, first of all, in terms of the petition, you'll see that the prayers themselves.
Just a minute, put on the, yeah.
Yes, my Lord, any suggestion that the application is going out of the prayers in the petition or the environments in the petition cannot be correct. And I did point out the paragraphs in the petition which relate to the application for scrutiny and so on. But specifically, if you look at the reliefs, if I may just pick on one of them, EF, that immediately upon the filing of the petition, the first respondent do avail all the material, including electronic documents. So, my Lord, if in the totality of the reliefs which are sought and in the body of the petition, it is quite clear that this particular application is quite anchored in the petition itself, and is not an attempt to try and balloon or broaden the petition. My Lord, I am asking myself the question, has the electoral system changed since 2013? Or is it the same manual system? When we had the manual system in 2013, this court had no hesitation to order for scrutiny of documents which included registers, the black book, and the other components of the register. And indeed, when we went to the Kenyatta International Center, the relevant election documents that are required to be scrutinized were made available through this court's order. That is because it was a manual system. Now, my Lord, for example, if this court wanted to know what is contained in the polls register, the register of voters rather, it would not be in a manual document. And for purposes of the elections, this commission made it possible for even private citizens, including political parties, to access its database, its website, to know who are the registered voters, because there are functions contained in the register which would not be found in a manual register if you wanted to know exactly the identifiers as required under the Elections Act. So if the system of the elections has changed, the best evidence to establish what happened on polling day, especially in relation to transmission of results, is to have the best evidence. And that best evidence is not contained in the forms of the Form 34As or 34Bs. Because the law is that what is contained in Form 34A is scanned and then transmitted and published on a public online portal. So that, my lords and my ladies, the Form 34A that is brought to this court physically or in a form of a document may not necessarily contain the same information that was transmitted. And for the purpose of verifiability and transparency of the elections, we need to know from the IBC-owned database, whether those Form 34As that they are willing to place before the court, does it contain the same material that was scanned and electronically submitted? My Lord, you've heard, even in the replies, they have said that what was contained on the online portal was just statistics. My Lord, it was not, because the results scanned at the polling station are final results. They are used for purpose of verification. My Lord, what do we want to achieve by making these prayers in the application? It's for purposes of verifiability. And we have raised questions in the petition and in this application to challenge the authenticity of these Form 34As and 34Bs, which are on record, to enable now the court, and indeed this petition is not all about the individuals before the court. It's not just the petitioners and the respondents. My Lord, the Chief Justice, in the article that was read by my learned friend, I think it was Mr. Karorio or Mr. Mwite, he forgot to read another part which is essential, that the elections is not just about candidates. And the general principles concerning election found in Article 81 is for purposes of ensuring that the right to vote is complied with, so that each vote counts. But my Lord, it did say in this article, and that is paragraph 5.1, the principal objective of judicial scrutiny, therefore, is to determine whether the electoral process was transparent, accountable, and verifiable. So, my Lord, the best evidence for this, as contained in Section 44, subsection 3 of the Elections Act, is that the technology established under the Elections Act. And, my Lord, this is what they are trying to run away from. They are trying to run away from it because the whole truth is contained in those logs and those transactions. And the best evidence about this election is not necessarily contained in the Form 34As and so on. And when those Form 34As are brought before the court and 34Bs, together with the transactions through transmission that were done electronically, if they are brought before this court, then this court will be able to verify whether that election was transparent, credible, and accountable. My Lord, I would say that the attempt to try and say that we have no time. What was this technology all about? It was for purposes of ensuring that the election is not an election on the day of election. Even after the election, a citizen, under the technology rules, can make an application for information, for satisfaction whether the election was transparent. And
Mr. Rengo.
Yes.
What you all counsel are not telling us is the time it will take. You are saying, wait a minute. You're saying yourself it will take a few hours. The other side are saying it will take even 3 weeks. I mean, do you have an expert opinion on this to tell us that this is a 30-minute exercise?
My Lord, for example, if I wanted to know access to the register, all I need is to have access. I don't need that server to be brought here. Once I'm given access, I can be able to determine who are the registered voters in the register of voters. Similarly, 40,000 forms which are scanned and is in the database, if I'm given access, it will not fill more than 400 pages of just seeing the transactions. In fact, if you look at the application, we're not looking for the hardware. We are talking about logs or what was transmitted from the devices at the polling station. That cannot even contain a page. It's almost instantaneous in as much as the same information was relayed directly to the National Tallying Center, to the constituency tallying center, and so forth. So, my Lord, what we are asking for, and if you look at the application, we are not looking for the kits. We are looking for the logs. And that is...
Sorry to interrupt. Really?
No, this is... No. It's not even been...
The evidence we wanted to show...
Just a minute, Mr. Kinyanji.
The logs would take...
Just a minute, Mr. Kinyanji, can please sit down? We'll, yeah.
Yes, my Lord, I'm saying this from expert advice. We're not crazy to bring this kind of application knowing the timelines. And in fact, this exercise is easier than bringing in the old order, bringing the ballot boxes and the manual registers and bringing the forms from all over the Republic. In a word, we will not need any paper if we have access. Probably the paper only we'll write on is the report that we'll submit before this court. And my Lord, information that is in the custody of a public body, that information, unless there are legal justification to keep it away from the public, cannot be, as it were, disallowed for a member of the public to access that information. And I think, and the law bears what I'm saying, that accessibility to the technology used by the electoral body in terms of the Elections Act, it was part of the architecture that voters, candidates should be able to have access, except when there's reasonable justification not to have that information. So, Moran, let me conclude by saying, a second look at this application, I can even revise that I don't need 20 hours. In totality of what we're asking this court, even 5 hours will be sufficient. Looking at everything that we need from this application. And why the IBC should be afraid, or anybody who won the election truthfully, for us to access that information should be questioned. If they conducted a free and fair...
I'm on my feet.
I'm also on my feet.
Yes, when I start my Lord, I understand the procedure to be. But my learned friends in your council, Honorable Senator Rengo, should be responding. He is re-arguing his entire case. He's not responding to our case.
Yes. I'm sorry, my time is up, but all that I was doing was responding to the arguments. I didn't create any new areas, and I made very good notes here, and I'm very good at taking notes, having gone to Alliance High School, by the way. So, my Lord, we pray that the orders in the notice of motion be granted, and the orders be limited for access to information that has relevance to this petition as prayed in the petition.
Thank you, Mr. Ranga. ISA for IBC or no, Mr. Mwite. Huh?
I appear with Mr. Isa for the chairman. Mr. Mwite is for IBC.
Yes, IBC. You were talking that if access is allowed, it can interfere with the what? The systems, the IBC systems in these machines. Oh, who said that? That was Isa.
It's also our position.
Yeah, okay, fine.
The integrity is compromised immediately.
Fine, let me ask. Mr. Isa, I'm not an ICT expert, but I thought there are securities that are, ingrained into those kind of systems,
Yes.
so that if you are allowed access, you can access what you can access, you can't. And you can't interfere with the record there. It will even show who has gone in, what time, and that kind of thing.
Well, look, as I made it clear, what they seek to do in terms of forensic audit will mean they have to get into the system. Before that is done, the Commission will require to do a backup of all its systems through its, because this is not them doing a return. I'm saying what we're explaining, that if that order was made, in terms of the way the prayers have been framed, and my lords, you'll have time to look at them when you consider the application, is that the Commission, in terms of the forensic tools that will come in, because they want to have unfettered, as that's what the word they use, and I say they can't be given unfettered to do what they want, because this is under a court-controlled process. What I was explaining is that before that exercise can be undertaken, the Commission, through its consultants and its IT experts, will have to ensure a comprehensive backup system is done.
No. I just wanted to know whether there's no security that can...
My lord, that's part of the security.
Okay.
That's part of the security, ensuring that that system, we do not know which routes they want to go in terms of the experts that they will engage. Once that process is over, then you want to ensure that you still have the system intact.
Thank you. Thank you. We will give this ruling also tomorrow. Now, can we deal with the pre-trial conference? We have seen what? Your issues. Council, you couldn't agree, even from these things, you can't agree on the issues that are there? Senior Counsel, Mr. Mwite, you can't agree on...
We did our best.
Yeah.
We even sat in the very good boardroom upstairs.
Yes.
Talked. You will notice that the petitioner has got 28 issues. And we have 3. And I think the third respondent has 5.
Essentially.
And when you look at the petition, because issues really should rise from what is pleaded in the petition.
Yes.
We were not able to agree. So that our plea is that perhaps your lordships and your ladyships might go through the issues we have raised, the issues that the petitioner has raised, the issues that the third respondent has raised, and we, as the bar, will be bound by the issues that the bench will crystallize. I think that is the fastest way of going about it.
Very well. So you are unable to agree. We will deal with that. Council, depending on the rulings we'll make on the applications that have been made, yes. Can we have an indication, Mr. Rengo, how long you will take, so that we are able to plan and know how we will deal with this?
I think, my Lord, working with the constraints of the court in terms of timelines, 6 hours to present our case, and about an hour to reply to what may come from the respondents.
All right.
Yes.
Very well. That's your indication.
Yes.
That's your indication, Mr. Who is for the first respondent?
If the petitioner is taking 6 hours, and you notice from the petition, there are two petitioners. Two petitioners. So it's like 3 hours for each. You said 6 hours. And I don't quite know why the deputy president was omitted. The running mate was put in as a petitioner. But I reckon that the first respondent and the second respondent, we would need 2 hours each. That's a total of 4 hours.
First and second respondent, 2 hours?
2 hours each.
Third respondent, Mr. Ngatia or Mr. Abnasir?
My Lord, we take the view that this is a trial where this court acts as a first instance because it will be a trial of the petition. And from the perspective of the third respondent, we need 4 hours to defend this case.
Yes. Very well. In total, we are talking of how many hours?
14.
About 14.
Although, my Lord, in fairness, we are taking 6 hours to present our case against the first and second respondents and also the third respondent. Altogether 6 hours. So, my Lord, really, on looking at the petition, the allegations against the third respondent are not as expansive as the claims made against the first and second. So really, in fairness and using equality of arms, if we take 6 hours to present our case against all the respondents, they should take a similar amount of time to respond to that case which has been presented in 6 hours.
Honorable Orengo, this would exclude any time that we may give, or in case we do give, we don't know, regarding the issue of the access or scrutiny.
Yeah.
Right?
That's how it is.
Yes, that excludes. My Lord, but it depends on how that is going to be done. It may not necessarily interfere with the flow of the presentation of the petition. If we craft it in such a way that whatever report comes to the court comes at the tail end, we need not wait until that report comes out. And I think that's what we did the last time in 2013. As the inspection was going on, the hearing of the petition was continuing.
So I ask them to
My Lord, may I, with your very kind permission, in 1 second, try and help the court with the benefit of our experience last time. I think we would have to release the court on Wednesday at the latest. And I was going to suggest to my colleagues that one team can take Monday and the other Tuesday, and we close. I was also going to suggest, my lords, that for tomorrow, instead of mobilizing the court to deliver the rulings, you deliver them electronically, freeing yourselves for more time for preparation. Thank you.
These are friends by force. Yeah, friends by force. They are friends by force.
The rulings will require scrutiny.
Emily, they are already friends.
They're
Americans become Americans
Thank you very much, the Honorable the Attorney General. We are able to take control of our processes. So the decisions will come from this side. But before that happens, please tell me, in the process, telling the court what time you want us to start hearings tomorrow, because we do propose that we start hearings tomorrow. What time is suitable to the chaplain of the Anglican Church? And the rest of us who want to go to church tomorrow, what time is suitable?
My Lord, I was praying that after you give the rulings tomorrow, and that's subject to the times that the court could allocate, that the substantive hearing will start on Monday. And tomorrow we come and get the rulings. They may have an impact on how you plan our presentations. And also, it may allow Paul Winter to go to church.
The thing is that we only have 14 days within which to hear and determine. Of the 14, 8 is gone, and we cannot afford to lose a minute. So we must, of necessity, start the hearings tomorrow. It is the time that I want to get consensus from that end about.
I was going to plead that actually we would move much faster from this side of the bar if we were given tomorrow to do our respective restructuring and preparations. I think we would then move a lot faster and we could start as early as Monday at 9. And really, we appreciate everybody here is conscious of the fact that obviously the judges are also human. We cannot expect you to spend the whole day listening to submissions by counsel and then go and spend the night writing the judgment. You need time. So we're pleading, if the bar could have Monday and Tuesday, and then leave the bench with Wednesday and Thursday, we would really move a lot faster.
Council, we have not complained. You have had time since the 18th, or indeed since the 11th, when these results were declared, to plan your cases. And when you talk about getting an extra day, you're taking that day from us. And you're the same people who have been saying you do not want a 1-minute ruling. So do not have mercy on us. We haven't been sleeping the last few days and we are still okay. And since we are not complaining ourselves, we are mindful that we must finish this matter within 14 days. We are mindful that what we give you on the 14th day is something that makes sense. And we need every minute we can get. Can we not start, let me be direct. Can we not start midday, 1 o'clock tomorrow? To allow whoever wants to do whatever they want to do with their maker, myself included, in the morning. And we come here, we haven't complained about not being able to sit tomorrow.
My Lord, my lady, on that note, can we come at 3 tomorrow?
You won't even have your 6 hours, or you will want us to sit until midnight and we are ready?
No, we can have our 6 hours.
You would like us to start at 3?
At 3.
Let's see. There is a consensus also from this end. So hearings begin, or the hearing proper begins at 3 p.m. Tomorrow, God allowing. You will have your 6 hours, Senior Counsel, Senator Orengo. In the morning, we will deal with, in the course of the day before 3 o'clock, we will deal with the rulings, and then we start the hearing tomorrow. The petitioner's case starts tomorrow at 3 o'clock.
Thank you. To assist you on to be able to organize your submissions, we propose to dispatch to the registrar the issues. Now that you have not framed them yourselves, the court will frame the issues from the pleadings and from what you have given us, around about 10 o'clock, so that you pick the agreed issues as framed by the court to enable you organize your submissions. Is that okay?
Yes. That is okay. We appreciate.
Yes.
My Lord, can I make a suggestion? My Lord, since there are a lot of parties here and there's a lot of documentation, could the court kindly facilitate a better environment than this? Some of the authorities, when we are submitting, disappear. If there can be an order on how the parties can conduct, so that there's quite some space when you are expressing yourself, because this is very, it's not conducive. And I would suggest, my Lord, can I suggest that each party, because we are only the petitioners and 2 respondents, can we have just 2 lawyers or 3 lawyers just to sit on the benches instead of, there are some parties who have come with 20, 30, it's not really necessary. The main lawyers can have an environment where they can really argue the case proper, because it's just impossible.
Mr.
If you allow me,
yes.
On that point only.
Yes?
My Lord, our suggestion was that when it comes to the presentation, when it comes to the 6 hours allowed to the petitioners, this bench be allowed for the lawyers of the petitioners. When it comes to the first respondents, we will vacate, and the lawyers for the first respondent take this bench in turns until the end, because it allows the space.
That sounds reasonable? Yes, ma'am. That sounds reasonable. I can see Mr. Sita Awela? Yes, ma'am. Awela, one of the lawyers here, standing. We cannot have that. Abdul Nasir, I hear you very well, and that's a very reasonable submission. So what we will organize, those council, those who are not actually for the parties, should be at the back. You squeeze yourselves at the back. Space allowing, please squeeze yourselves at the back. That's why we have we have limited the public. The public would have come in, but that's why we have put television sets for them to watch, simply because of the size of the court, so that we are able to proceed properly. Those who are not actually appearing for the parties, please sit at the back. We will try and get as many loose chairs as possible, but you allow the media to be able to do their work, and we move on. We have also our law clerks who should get a place to sit. So the registrar will organize that tomorrow, and we will require your cooperation on that.
Clarification.
Yes.
Earlier, the communication was that the rulings will be delivered at 9 a.m. Does that remain the position?
Let them all come at 3.
My Lord Chief Justice.
Since we are starting at 3,
Yes.
we will come and deliver the rulings at 2.
Yes.
So that at 3 we start on with the hearings.
I think that is reasonable.
Okay.
I was just seeking a clarification.
Thank you. Thank you very much for that clarification.
Yes.
We will now adjourn. Huh?
My Lord, just a matter of probably housekeeping. In volume 5 of our documents, they were unpaginated. And we are asking for your indulgence and learned friends if we can give paginated copies of that volume. We don't take away the volumes that are already with the court, and we don't take the volumes that they have, but give them an additional volume, which is paginated. That is one request that we wanted to make. The second one was in relation to evidence which we wanted to adduce before the court that would require a television screen and a projector. Of course, at the appropriate time, we will show the court that all that is required to do under the law to present such evidence has been complied with. But on the safe side, that arrangement should be made before we start tomorrow. And the response, I think they also have evidence of that nature.
On that one, Mr. Orengo, can you please liaise with the registrar of the court? Then she will brief us and we will see what to do. Your request for the pagination, you know your colleagues here, I don't know whether they are not going to raise issues that you have added other copies. I hope there will be nothing like that.
That's why we are saying they keep the copies they have.
Yeah.
And give them an additional copy, which is paginated.
Yeah.
And if there is anything untoward, then we'll immediately withdraw.
Okay.
Yeah, but we've gone through it. It's the same document, and it's just for purposes of pagination.
No objection to that?
I think, my Lord Chief Justice, you had suggested that he liaises with the registrar.
Okay.
And not rather we go that route while we think about whether there is anything that we are missing, because the approach appears to be quite close to juri jeke. You know, you have a document, you want to change it. So let's think about it while we liaises with the registrar.
No, my Lord, that's very unfair. I'm an officer of the court, and those aspersions are not very good.
No, we want to think about it.
No. Jury check, I'm not a member of that class.
That's not the approach.
Yeah, so I think the court gave us some advice which we should follow.
Mr. Orengo, what you do, bring the documents and keep them here.
Yes.
So that anybody wishing to, when you are referring, then they can pick.
Yes.
Yeah.
That's reasonable.
Thank you very much. Thank you very much once again. We will now adjourn.